Hi, this is Nate Charles, and welcome back to the Rule of Law Brief. Today is the second installment fired by some questions from one of our listeners. Yesterday, we covered the distinction between war crimes and crimes against humanity. Today, we're getting into a slightly more complicated topic, which is who is responsible for enforcing the laws of armed conflict and what institutions are responsible for prosecuting war crimes and crimes against humanity. Now, the reason that this is such a complex topic is because it gets to the very concept of national sovereignty. Okay, so what do I mean by sovereignty? Under international law, there are essentially four elements to the concept of sovereignty. One, a country that is sovereign will have supreme authority within its territory. There's no superior authority that can tell that state what to do within its own territory. Two, the country has to have independence from external controls. Very similar concept. Three, it has to have equality with other states in the world. Essentially, it's on the same legal footing as any other nation state. And then four, it can't be subordinate to any other state. Again, there can't be any other institution, any other nation state that exerts authority within its own territory. Understanding the concept of sovereignty is important to understanding who is responsible for enforcing the laws of armed conflict and prosecuting crimes against humanity. It helps to think of it this way. If the most basic form of a war is a contest between two nation states, and both those nation states are sovereign, they both meet those elements of sovereignty under international law, well, then who is responsible for enforcing the laws of armed conflict if there is a violation during that war? Again, there is no world government. Not really. So who is responsible for upholding international law? So with respect to war crimes, the Geneva Conventions actually specifically address this. The combatants themselves are supposed to be responsible for enforcing the Geneva Conventions. Now, obviously, this isn't going to be a perfect system. It really depends on all the sovereign nation states of the world to uphold the law in good faith. But still, the explicit terms of the Geneva Conventions require that any nation state signing on to the Geneva Conventions search for persons alleged to have committed grave breaches of the laws of armed conflict, specifically the Geneva Conventions themselves, and bring them before their own courts or extradite them to a state willing and able to prosecute them. Now, again, it's a voluntary system. So is every nation state going to adhere to those provisions all the time? Probably not, but it's the best that we've been able to do. The bottom line is, with respect to the laws of armed conflict and the Geneva Conventions in particular, there is no global prosecutor, there is no global court, and there is no global police power. Each state that is signed on to the Geneva Conventions is required to enact legislation criminalizing grave breaches of the Geneva Conventions themselves, required to investigate their own personnel, required to prosecute or extradite people who violate the Geneva Conventions, required to prevent, suppress, and report violations of the Geneva Conventions, and required to ensure respect by its military forces and civilians. That is, respect for the Geneva Conventions. Now, acknowledging that this was going to be an imperfect system from the get-go, the Geneva Conventions do have a sort of enforcement mechanism called the protecting power system. Now, under the Geneva Conventions, each party to a conflict is supposed to appoint a protecting power, i.e., a neutral state in the conflict. The protecting power is supposed to monitor that country's compliance, access to prisoners, and to supervise the treatment of both POWs and the civilian population during that conflict. However, very few countries actually do that because to appoint somebody to supervise your conduct in a war would be, to a pretty reasonable degree, an infringement upon your state sovereignty. So in reality, this protecting power system doesn't work very efficiently. Now, the International Committee for the Red Cross can serve as that sort of neutral authority during conflicts if the states agree. But again, the International Committee of the Red Cross has almost no enforcement authority. It has no military, it has no police force. All it can do is observe and report back to the rest of the world community. Okay, so what about the International Criminal Court? Well, it's important to remember that the International Criminal Court was only created by the Rome Statute in the late 1990s. Even then, the International Criminal Court has only limited, supplementary, and conditional jurisdiction over war crimes. The primary enforcement of the laws of armed conflict is supposed to be the nation state involved in the conflict. The International Criminal Court is not the primary enforcer of the laws of armed conflict. The nation states involved in the conflict are. The International Criminal Court is a court of last resort. Under the explicit terms of the Rome Statute, which again is really just a multilateral treaty, there's actually a relatively complex analysis that determines whether the International Criminal Court can assert jurisdiction over war crimes. First, there has to be a legitimate jurisdictional basis, which means that one of the following three conditions has to be true: that the crime occurred within the territory of a state party. And when I say state party, I mean a state that is a party to the Rome Statute. Two, the accused has to be a national of a state party. Or three, the UN Security Council refers the situation to the International Criminal Court. Essentially, the UN Security Council says so. The second layer of the analysis is called complementarity, which basically means that the member state has to be unwilling or unable to genuinely investigate or prosecute the conduct, and there's no genuine national proceeding addressing the same conduct. What this essentially means is even if the ICC has theoretical jurisdiction, it can't act if the country is already taking steps to enforce the conduct. That alone can defeat International Criminal Court jurisdiction. This isn't a bug, it's a feature. It's how the system was intentionally designed in order to preserve that concept of state sovereignty that I discussed in the beginning. And again, the country doesn't even have to be trying all that hard. And even then, the ICC will not assert jurisdiction unless the conduct falls into one of a few very serious categories of misconduct: genocide, crimes against humanity, which we'll talk about in a minute, national aggression, or a specific set of war crimes that are listed in Article 8 of the Rome Statute. Okay, so up to this point, we've really only talked about war crimes. What about crimes against humanity, which, as we determined yesterday, are different and far more serious? Well, as of today, and in fact, as of July 1st, 2002, the date when the International Criminal Court actually started operating, the International Criminal Court is the body that's responsible for prosecuting crimes against humanity. But again, it's only if those crimes meet that jurisdictional threshold that I discussed earlier. Again, the crime against humanity has to occur within the territory of a state party. The accused has to be a national of the state party, or the UN Security Council says so. Prior to the opening of the International Criminal Court, all prosecutions for crimes against humanity were conducted within special ad hoc tribunals. The first one, which we've already discussed at some length, was the Nuremberg trials. But again, what was the legal authority for the Nuremberg trials? The fact that the Allies had won World War II. There really wasn't anything more sophisticated to it than that. It was a victor taking the spoils sort of system, if we're being honest. But there have been other special tribunals that have been convened by the UN Security Council to prosecute crimes against humanity, subsequent to the Nuremberg tribunals. Two of the big ones were the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda. I'm really not going to get into the history of what happened in the wars in Yugoslavia, the former Yugoslavia anyway, nor am I going to get into the details of the conflict that took place in Rwanda. But there were mass atrocities that amounted to crimes against humanity that took place within both of those conflicts. And in both of those cases, the UN Security Council convened a special tribunal to prosecute the crimes against humanity that occurred there. And as we've already said before, the UN Security Council retains the right to do that again. It can refer crimes against humanity to the International Criminal Court, even if those crimes don't necessarily satisfy the other conditions set forth in the Rome Statute. And why can they do that? Because they have the power. Because the 5 permanent members of the UN Security Council are the 5 most powerful countries on Earth. It's not a very elegant legal answer, but it is the truth. Okay, so we're going to stop there. We're going to release a third video tomorrow that discusses why the United States does not participate in the International Criminal Court, because that is a topic unto itself that deals with some very sticky issues involving international law, the power of the UN Security Council, and U.S. foreign policy. So please check back tomorrow for some more information about this very important topic.